The People's Democratic Party and its candidate Atiku had on the 21st of March filed their petitions challenging the emergence of President Bola Tinubu in the February 25 elections. The petitioners' petition, which was among the 3 petitions remaining following the withdrawal of Action Alliance and the Action People's Party from the race, were given 3 weeks to prove their case before the respondents, INEC, Tinubu and APC opened their defense when the pre-election reports were delivered on the 23rd of May 2023. So far, the petitioners have called 27 witnesses to prove their case, amongst other documents tendered. The petitioners kicked off by calling 3 presiding officers of the Independent National Electoral Commission (INEC), who told the court that the refusal of Beavers to transmit the presidential election results on election day frustrated their jobs. The officers testifying on subpoena admitted that the results of the Senate and the House of Representatives were transmitted unhindered, and that the problems of the technical hitches arose at the point of transmitting only the presidential poll results. The 3 witnesses are Janet Nuhu Turaki, Christopher Bulus Ardo, and Victoria Sani, who served as INEC presiding officers at Yobe, Bauchi, and Katsina states, respectively. Day 2. The petitioners told newsmen that they might call additional 5 witnesses to have a round figure of having called 30 witnesses. Counsel for PDP Chris Uche said that some of the documents to be tendered in the remaining 2 days would take the place of the remaining 70 witnesses. Meanwhile, the Allied People's Movement, APM, which is seeking to nullify the election of President Bola Tinubu, closed its case after calling its sole witness. The witness, Aisha Abubakar, who identified herself as the Assistant Welfare Director of the party, tendered 7 batches of documentary evidence before the court to establish their case. APC's lead counsel Lateef Fagbemi tendered a copy of the Supreme Court's judgment, which the respondent said had earlier settled the issue the APM raised in the petition. The court admitted it as evidence despite objections from the APM. The court subsequently adjourned the matter till July 14 for all the parties to adopt their final briefs of argument, and the APM closed its case. On day 3 of the proceedings, the 26 petitioners' witness in the petition of the People's Democratic Party testified that the results contained in the 110 Beavers machine he inspected were deleted. Hitler Owala, who is a forensic analyst, tendered 7 volumes of reports based on the 110 Beavers machines inspected. While being interrogated by INEC counsel, he admitted that he was not in Abuja when the elections was conducted and that nothing was wrong with the Beavers machine when he inspected them. He added that he didn't interview any of the election presiding officers and did not know if anything was wrong with the Beavers machine on election day. INEC further told the court that the 110 Beavers machines inspected in the Federal Capital Territory constitutes only 3.5% out of the 3,163 devices allocated to Abuja and less than 0.06% of the total number of Beavers deployed across Nigeria. To verify the witness claims on deleting of results, INEC's lawyer brought 4 Beavers devices for the witness to inspect, but he refused, saying it was professionally wrong to do so, as the figures might be tampered with. Owala added that he can't identify the Beavers machines given to him as one of those he interrogated.
And as part of our strategy today, we called a very vital witness, a digital forensic expert. And you remember that this is the very first time we are having a technology-driven presidential elections in Nigeria. So the evidence that this witness has profiled today, a witness who examined the Beavers machines used, is very, very vital. So we are happy this witness has testified today. Tomorrow we'll bring our remaining witnesses and we're able to round off our case on that note, having called 27 witnesses. So, and as the law permits us, and also in accordance with the pre-hearing report, we have eventually closed the calling of evidence by the petitioner. So the next stage now is for the respondents, if they have any defense, they will bring forward their own witnesses, and it will now be our turn to cross-examine those witnesses. If we have documents to challenge them with, we will do so. When they finish calling their witnesses, they too will close their case formally, and then the parties will now address the court on issues of law. That's why you see most of the times questions are asked, we say these are matters for address, because there are legal issues that at the end of the day will address the honorable court on. So we are very happy that this second stage will finish with the pre-hearing. Now we have concluded with the presentation of the petitioner's case, and we're very happy reviewing entirely what has been presented before the court. So we'll now wait to hear from the respondent, and when they finish, we all leave everything in the hands of the court. Thank you very much. Yes.
The witnesses you've presented so far, especially the key witnesses.
Yes.
Their submission seems, from an observer standpoint,
yes.
Their submission seems to be undoing the case of your clients. Can you speak otherwise than that?
You see, like I said, we try not to touch the merits of the case. What we usually will want to do is just to inform you the stages at which we are, even though it would have helped to enlighten you, on that, but we'll refrain from so doing. Yes, it's for the court to determine, but our responsibility is to present the case, which we have done by the documents you saw we tendered, as well as the witnesses we called. There's a division of labor in this industry. The lawyers will do their own bit, the lawyers for the petitioners, the respondents will do their own bit, and then the court will summarize everything and then present the judgment.